Hey everyone, Chase Elleby and Joel Williams from Williams Elleby, and today we're going to talk to you about comparative fault, and if there is comparative fault, can you still recover? So Joel, what is comparative fault?
So comparative fault is really just a percentage that can be assigned to different parties, looking at what percentage they are responsible for causing this incident. So if you're the plaintiff, you may be partially at fault for causing a wreck.
Right.
The defendant may be at fault. There may be non-parties that are at fault, so we're comparing the fault of everybody and trying to assign a percentage to it.
Right. So there's a pure, with a pure and modified comparative fault, correct? So what's pure and modified?
Yeah. So different states have different laws when it comes to whether you can recover when you are at fault or partially at fault. In pure comparative fault states, you can recover even if you are more than 50% at fault. So if you're 70% at fault and the other person's 30% at fault, you can still recover 30% of your damages because that's what the other person's responsible for. However, in modified comparative fault states, like Georgia, the state that we're in, if the plaintiff is 50% or more at fault, they cannot recover anything.
Okay.
So the way that shakes down is if a jury would award you $100 and you're 20% at fault and the defendant's 80% at fault, then you'll recover $80.
Right. Yeah, and that was going to be my follow-up is, so what does it all mean when it comes to your damages and injuries? Is basically the percentage of whatever a jury decides, how they allocate it will decrease your reward based on your damages.
That's right. Yeah, it's a proportional reduction based upon whatever percent is assigned to the person making the claim.
Right.
But the trick in that previous example is in a modified comparative fault state, the trick is if the jury says you have $100 in damages but you're 50% at fault, you get zero. Right. So you got to be very careful about that. Now, who determines fault?
Right, the juries. Mm-hmm. Right. So when we go to trial, we're plaintiff's lawyers, right? So on the plaintiff's side, like Joel alluded to earlier, if we think there's multiple parties or defendants that owe our client money for damages that they caused, then we'll likely have them as party defendants. Mm-hmm. Okay, so everyone's at the table. The defense, on the flip side of that, if they think there's a non-party at fault, they'll try to point the finger at these non-parties to get the percentage of damages against them reduced, by however much they want to argue that these non-parties are at fault. So all that is left for the jury to decide, okay, well, who is really at fault for what? If we have the pie, right, what pieces of the pie go to each defendant or each non-party or even the plaintiff?
Yep. And so the only person that can legally assign fault is the person who's determining who wins and loses, and that's usually the jury, right? Sometimes you may have a bench trial and the judge will assign it, but I say that because insurance adjusters so often will call people up and say, well, we've determined that you're 20% at fault and our insured's only 80% at fault, so we're only going to pay you 80% of what we think your damages are. Right. My response is, well, I appreciate you giving me your opinion, but you don't assign the fault.
Right.
So don't let an insurance adjuster fool you into believing that they can just unilaterally assign a percentage of fault and reduce what they have to pay you.
Yeah, and that happens more often than it should, honestly. And especially in cases where it's a standard rear-end collision. I've had insurance companies try to say, well, yeah, we know it's a rear-end collision and my client might have been following too closely, but we think maybe the client or your client or the car in front of it slowed down too soon, so we're going to assign maybe 10-15% of the fault to your client for maybe braking a little too sudden. And I'm like, in what universe is that even a thing? But they try to make that argument all the time. An even better one is I had an insurance company that rhymes with Schmeikno try to say that the lady who pulled out in front of my client was at a stop sign and there was a bush in this person's yard. And the insurance adjuster was trying to say, well, that bush probably shouldn't have been there. So we think the homeowner who's responsible for that bush bears about 20% of the fault, which was the justification for the terrible offer that we got. And I respectfully disagreed with her opinion and filed suit. And surprisingly, there was no mention of that bush at all during the litigation, and they finally paid a fair amount. But
Yeah.
all that to say, they'll try to use the tactic of comparative fault to reduce what they think is owed.
Yeah. And a classic example that if somebody has pulled out in front of you in a car wreck case and you run into them, this is why we always tell people, be very careful about recorded statements to insurance companies, because they'll ask you something like, well, how long did you see them before you hit them? Did you press the brakes? How hard did you press the brakes? And the answers to those questions, the insurance company will then come back and try to use it against you to reduce what they have to pay. Well, we think you could have hit the brakes quicker.
You should have seen them sooner. You should have known that crazy driver's going to pull out in front of you.
All these things, yeah. So it can be used as a negotiation tool, but just be aware if you start getting that from an insurance company to try to reduce what they have to pay, that's just their opinion. It's not fact.
Right.
Exactly. So, but yeah, that's comparative fault, and you can still recover even if you have a percentage of fault. And how much percentage of fault you can have and still recover is going to be specific to the laws of the state that you're in or the state where you would bring the claim. So make sure if you feel like you may have some fault in a wreck, when you have that consultation with the attorney, talk to them about it, get some personalized advice for the state that you're in. But anything else on comparative fault?
No, I think we've covered it.
All right. Well, I hope this video has been helpful to you. So give us a thumbs up, hit that subscribe button, and we'll see you next week.